It was a quiet morning in Hyde Park, the kind that wrapped London in a soft grey mist. Joggers passed by Victorian lampposts and cyclists zipped past statues as if history itself was just a backdrop. But inside one elegant flat overlooking the park, a place worth over £1 million, sat a man whose story would soon stir national debate and legal circles alike. His name was Faiz Siddiqui. At first glance, Faiz appeared every bit the accomplished professional. An Oxford graduate in history, polished, articulate, with the calm cadence of a trained solicitor. Years ago, he had walked through the prestigious halls of Clifford Chance, one of the world's leading law firms, armed with ambition and elite credentials. The future was wide open. But that was then. Now, at 41, Faiz hadn't worked in nearly a decade. His days passed mostly indoors, curtains drawn, laptop open. A sense of expectation hung over his life like a soft but unyielding fog. Bills? Handled? Rent? None. The flat was a gift, technically owned by his parents, Javed and Rakshanda Siddiqui, wealthy retirees living thousands of miles away in Dubai. Spending money? £400 per week, courtesy of Mum and Dad. Utility bills, groceries, maintenance, everything paid for. For over 20 years, they had ensured he lacked for nothing. To outsiders, Faiz was living what many would call an enviable life. But underneath that quiet surface, something was beginning to shift. His parents had started pulling back. First, it was a reduction in the weekly allowance. Then came firmer messages. You need to move on. Start again. Get help if you must, but you can't depend on us forever. For Faiz, it wasn't just a financial blow, it was personal, a betrayal. After years of consistent support, after building a life around that support, how could they suddenly pull away? He didn't just want the money reinstated, he wanted justice. So he did what few sons would ever imagine doing. He sued his parents. But this wasn't an ordinary family spat. It would soon become a landmark legal case, one that would ask uncomfortable questions about responsibility, dependency, and the legal limits of love. As Faiz prepared to take his battle into the courtroom, lawyers on both sides braced for impact. What started as a private feud between a son and his parents was about to explode into headlines, challenge decades of legal precedent, and force the courts to confront one radical question. Do wealthy parents have a legal duty to support their adult children? Forever? From the moment Faiz Siddiqui took his first steps into the hallowed halls of Oxford University, expectations followed him like shadows. His parents, Javed and Rakshanda Siddiqui, had done everything right, by conventional standards. They were wealthy, deeply involved, and endlessly supportive. For them, Faiz's future wasn't a question, it was a plan. He would excel, and for a while, he did. Graduating with a 2:1 in history from Oxford, Faiz entered the professional world with the kind of credentials others would envy. He trained at Clifford Chance, a firm where ambition met its match in relentless excellence. He later moved through other prestigious names: Burgess Salmon, Field Fisher Waterhouse. His path, on paper, seemed secure, but something was already cracking beneath the surface. While others climbed, Faiz stalled. Slowly, his career lost momentum. By 2011, he had left the workforce entirely. Years passed. Resumes gathered dust. The polished exterior remained, but the professional engine behind it had stopped running. To the outside world, he had vanished. To his parents, he had become something else entirely, a dependent adult. Their response? Generosity? Guilt? Perhaps a quiet sense of responsibility? They gave him more. A luxury flat in Hyde Park, rent-free. Utility bills, paid in full. Weekly allowance, £400, no questions asked. This wasn't just parental love, it was long-term sustenance. And in time, it became the very foundation of Faiz's world. The flat was more than shelter. It was stability. The allowance wasn't pocket money. It was survival. But as the years wore on, the line between support and obligation blurred. Javed and Rakshanda had done what many affluent parents do. They gave freely, privately, without legal structure or formal agreements. But they hadn't expected it to last forever. Faiz, on the other hand, began to believe it must. He viewed their help not as kindness, but as necessity. After all, he hadn't just been supported, he had been shaped by that support. It allowed him to avoid work, to avoid facing the chaos of a world he now claimed was impossible to navigate due to his declining mental health. In his eyes, his parents had nurtured his dependency. And now, cutting him off wasn't just unfair, it was inhumane. The tension grew. Phone calls turned sharp. Emails went unanswered. A single disagreement snowballed into a full breakdown in the relationship. Then came the final blow. The money stopped. No more allowance. No more assurance. Faiz was stunned. For a man who hadn't earned an income in over a decade, it was existential. He didn't seek therapy. He sought a barrister. And soon, he would walk into court not as a son pleading with his parents, but as a former solicitor wielding law like a sword, arguing that dependency, if nurtured long enough, becomes a right. What began as a financial dispute between three people was now being framed as a battle over human rights, statutory duties, and the very definition of family. Faiz was ready to sue, not for damages, not for inheritance, but to compel his own parents to keep supporting him, possibly for the rest of his life. And with that, the courtroom lights flickered on. The country was about to watch one of the most unusual family legal battles ever to reach the UK courts. When Faiz Siddiqui filed suit against his own parents, even seasoned legal professionals blinked in disbelief. This wasn't a custody battle. This wasn't about inheritance. It wasn't about abuse or neglect or any of the usual triggers that pull families into court. This was different. It was a 41-year-old man, an Oxford-educated former solicitor, arguing that his wealthy parents had created his dependence through 2 decades of support, and now had no right to withdraw it. He wanted the court to force them to continue paying. And he wasn't going in alone. Faiz had retained top-tier legal firepower. Represented by Hugh Southey QC, a barrister known for high-profile human rights cases, Faiz would attempt to construct a bold, even radical legal argument, one that danced on the edge of both statutory interpretation and emotional appeal. Southey would argue that Faiz was not just an adult child, but a vulnerable adult, someone whose long-standing mental health issues, combined with his parents' enabling behavior, had rendered him incapable of independence. And under the law, that made him eligible for protection. At the heart of their case was the Children Act 1989, a statute designed to ensure the welfare of minors. But Southey suggested that Schedule 1 of that act, which allowed for financial provision, could, in special circumstances, extend to adult children as well. Faiz's life, he claimed, was a special circumstance. And then there was the European Convention on Human Rights. Southey pushed further. By cutting off his allowance, Faiz's parents had infringed on his Article 8 rights, the right to family life. And not only that, they had interfered with his property rights under Article 1 of Protocol 1 because after 2 decades of financial support, that money, he argued, had become an expected resource, a kind of de facto entitlement. It was a sweeping legal gambit, part human rights, part statutory stretch, part moral plea. But the Siddiquis didn't back down. They returned fire through their own heavyweight legal counsel, Justin Warshaw, QC, who painted a very different picture of their son. He described Faiz not as a victim, but as a man of great privilege who had squandered every opportunity life had handed him. He had been difficult, demanding. And now, after more than 20 years of ungrateful dependence, he was turning on the very people who had kept him afloat. Warshaw reminded the court, Faiz was not disabled in any legal sense. He was not financially destitute due to injustice. He had chosen not to work, and the law, he insisted, did not and should not compel parents to support capable adult children, no matter how wealthy those parents might be. To grant Faiz's claim, Warshaw argued, would send a chilling message to families everywhere. That parental generosity could one day become a legal obligation. That love could be turned into liability. The courtroom was tense. Legal observers were divided. If Faiz succeeded, it could change the fabric of family law in the UK, perhaps even in other common law countries. No one knew what the court would decide. But what was certain was this. For the first time in modern British history, a judge would have to answer an almost unthinkable question. Can a parent be forced to keep financially supporting their grown child because they always have? The courtroom was hushed. Journalists clutched notepads. Legal observers leaned forward. Even seasoned clerks seemed unusually alert. What was unfolding inside this quiet chamber wasn't just a family matter. It was an unprecedented collision between family life, financial dependency, and the full force of British law. At the center of it stood Faiz Siddiqui. Dressed sharply, as if to remind the world of his former life as a solicitor, he sat behind his legal team, composed but tight-jawed. This was more than a lawsuit for him. It was a stand for dignity, perhaps even identity. After all, the man who once wore the robes of the law was now challenging it head-on. On the opposing bench sat his parents' legal representatives, their expressions neutral, voices measured. The Siddiquis themselves, now living in Dubai, did not appear in person. But their absence seemed to echo louder than their presence would have. It was a son suing two unseen figures, once caregivers, now legal adversaries. Presiding over this delicate case was Sir James Munby, one of the most experienced family law judges in the country. He was no stranger to moral complexity or uncharted legal territory. But this case, even by his standards, was something different. The arguments began. Faiz's barrister, Hugh Southey QC, laid out the case in careful, deliberate tones. His client, he argued, was not simply a man out of work, but a vulnerable adult whose condition had been exacerbated by decades of dependency fostered by his parents. He cited Schedule 1 of the Children Act 1989, suggesting that in special circumstances, the law could stretch to accommodate adults like Faiz, especially when mental health played a role. He painted a portrait of emotional and psychological entanglement, of financial reliance born from years of unconditional support. And then came the human rights angle. Southey declared that by cutting off support, the Siddiquis had violated Article 8 of the European Convention on Human Rights, the right to respect for private and family life. They had, he claimed, disrupted Faiz's entire existence. That support wasn't just generosity. It had become, in effect, his property. Removing it, he argued, breached Article 1 of Protocol 1, protection of possessions. It was a bold argument, and it demanded an equally forceful rebuttal. When Justin Warshaw QC rose to speak, his approach was colder, more clinical. He began not with Faiz, but with the law itself. There was no precedent, Warshaw emphasized, for forcing married parents to support an adult child. Parliament had been deliberate in limiting the Children Act's reach. Faiz was not disabled under the law, nor was he incapable of working. His long unemployment, Warshaw argued, was not evidence of vulnerability, but choice. Then, Warshaw turned personal. He described Faiz as difficult, demanding, and pertinacious. A man who had already filed, and lost, a £1 million lawsuit against Oxford University for the classification of his degree. A man who had been supported by his parents far longer than most would dream of, yet now accused them of abandonment the moment they said, enough. And then Warshaw delivered the line that would echo in legal commentaries for months to come. Parental generosity is not a life sentence of obligation. The room fell silent. By the time both arguments rested, the courtroom was steeped in tension. This was no longer just about Faiz and his parents. It was about something larger, a cultural question, a legal boundary, a warning flare about the risk of turning familial goodwill into enforceable duty. All that remained now was the ruling. The air inside the High Court felt heavier than usual on the morning of the ruling. Reporters stood outside, camera crews prepped for live segments, and legal pundits waited anxiously. Inside, Faiz Siddiqui sat in quiet anticipation, shoulders square, expression fixed. It had been months of preparation, argument, and scrutiny. Now came the judgment that would decide the fate of not just his case, but the boundaries of parental responsibility in the United Kingdom. When Sir James Munby, the presiding judge and former president of the family division, entered the courtroom, there was no performance in his delivery, no grand speech, just a firm, meticulous dismantling of Faiz's case, line by line, statute by statute. He began with the law itself. The Children Act, 1989, Munby ruled, was never intended to provide for adult children unless the parents were unmarried or divorced. A clause written precisely to allow financial orders in the context of separation. Faiz's parents were married and living together. The act simply did not apply. As for the Matrimonial Causes Act 1973, also irrelevant, it offered no basis for claims by grown children against their married parents. The judge went further. Even the inherent jurisdiction of the family court could not stretch to meet the kind of request Faiz was making. This wasn't just a misinterpretation, it was an unprecedented overreach. Then came the matter of human rights. Faiz's invocation of the European Convention on Human Rights, namely Article 8, Right to Family Life, and Article 1 of Protocol 1, Right to Possessions, was summarily rejected. Sir James made it clear, the ECHR does not and cannot create financial obligations between private individuals, even if they are family. Family life does not guarantee financial life. In no uncertain terms, Sir James Munby declared the case to be unarguable and without legal foundation. It was a blunt end to a complex narrative. Faiz had lost. The legal defeat was not just personal, it was historic. The ruling reaffirmed, in resolute legal language, what many saw as an unwritten social contract, that parents are not legally bound to provide for adult children no matter their past generosity, emotional bonds, or financial means. Even in moments of family conflict or hardship, law cannot, and should not, enforce moral obligation. When Faiz filed an appeal, legal circles buzzed once more. But the result in the Court of Appeal the following year was no different. Lord Justice Moylan upheld the original ruling, adding weight to the precedent. He stated firmly that UK law reflects understood social norms and does not support claims like Siddiqui's. To allow such an argument would, he warned, radically extend the reach of family law beyond what Parliament ever intended. And just like that, the door Faiz had tried to open, for adults to sue their parents for ongoing support, was shut, locked, and bolted by two of the highest family law authorities in the land. The case was over. But the impact? That was just beginning. Long after the final ruling had been handed down, the ripples of the Faiz Siddiqui case continued to spread through dinner tables, legal columns, and lecture halls across the country. The headlines came fast and unrelenting. Oxford-educated man sues parents for allowance and loses. Entitlement or vulnerability? UK court rules against 41-year-old in landmark case. Parental support is not a human right, judges say. News outlets, from the Daily Mail to The Guardian, seized the story. Some painted Faiz as a symbol of generational entitlement, a man who had every advantage but failed to take flight, and then blamed the very people who had cushioned his fall for too long. Others were more measured, questioning whether long-term dependency could become, under certain conditions, a legitimate legal concern in the modern world. But the public had largely made up its mind. Comments sections boiled with outrage. Some accused Faiz of exploiting his parents. Others blamed the parents for enabling him for so long. Still others fixated on the bigger question: what does society owe to those who can't, or won't, stand on their own? Meanwhile, the legal world took note. Professors and practitioners dissected the case, recognizing it as a powerful affirmation of legal restraint in private family matters. The judiciary had drawn a clear line. Moral obligations within a family may be powerful, but they are not enforceable by law. To do otherwise, as some scholars put it, would turn courts into referees of unresolved family guilt. In classrooms across the UK, Siddiqui's case was soon being taught, not just as a quirky legal footnote, but as a cautionary tale. A reminder that even the strongest emotional ties, when funneled into legal systems, can become brittle, public, and unforgiving. And what of Faiz, the man at the center of it all? He retreated from public view. His past lawsuits, including the highly publicized and unsuccessful £1 million claim against Oxford University, were dredged up again by the press. His academic record, once a point of pride, was now part of a public narrative of discontent and dissatisfaction. His parents remained in Dubai, silent throughout. Perhaps relieved, perhaps heartbroken, perhaps both. The £1 million Hyde Park flat still stood. The allowance was still gone, and the court had spoken with finality. But the case had done something more than just rule against Faiz. It had clarified a cultural shift. The days of unquestioned lifelong parental duty to adult children, at least in the eyes of the law, were over. Families might give out of love, guilt, or tradition, but never again would that generosity come with the risk of being summoned to court when it stopped. The city moved on. The courts moved on. But in the quiet Hyde Park flat, time felt slower. Faiz Siddiqui, once a promising solicitor in crisp suits and polished shoes, now lived with a silence that echoed louder than the court's rejection. His legal career was a chapter closed. His public image, battered, analyzed, ridiculed, had slipped into a space few ever return from. He had challenged his parents in a courtroom. He had argued that support, if sustained long enough, becomes a right. That dependency, if nurtured, becomes a bond not just of love but of law. But no law had agreed with him. His parents, Javed and Rakshanda, remained overseas. They spoke rarely, if at all. Years of silent giving had collapsed into a wall of silence. Whether they felt guilt, grief, or cold relief, only they knew. The lights still turned on in the flat. The heating still worked. But the weekly allowance never returned. The distance between the man Faiz once was and the man he had become now stretched longer than the hallway outside his door. And yet, somewhere in the undercurrent of his mind, the argument still flickered. They raised me this way. They created this life. They can't walk away. But the courts had spoken. And in the eyes of the law, adulthood had boundaries. Parenthood had limits. Love, once broken, could not be legislated. Faiz Siddiqui didn't lose a case. He lost the world he believed he still belonged to.